Okay, good evening, Taxpayers Association of Indian River County. Tonight, I have the pleasure of moderating a forum between incumbent Judge Victoria Griffin and Lou Larsen, who are both running for Circuit Judge in the 19th Judicial Circuit, which encompasses Indian River, Martin, Okeechobee, and St. Lucie counties. Each candidate will have 2 minutes to make their opening statement. I will allow 2 minutes to respond to the questions I've selected and 2 minutes for closing statements. A quick reminder to all of our voters, early voting starts on August 8th and election day is right around the corner on August 18th. So please get out and make your vote count. And without further ado, I'd like to give the Honorable Judge Griffin the honor of making her opening statement first. Judge Griffin.
Well, good evening. Thank you to the Indian River County Taxpayer Association for the invitation and the opportunity to participate in this forum. I am Judge Victoria Griffin, and I am running for re-election as your circuit judge. I am currently a circuit judge for the 19th Judicial Circuit and have been privileged to serve the citizens and families of our communities in this role for the past 5.5 years. I was born and raised on the Treasure Coast, as were both of my parents. I am married, and we have 2 children who attend local schools. I have been licensed to practice law for the past 17 years after graduating cum laude from Nova Southeastern University with my Juris Doctorate degree. My experience prior to becoming a member of the judiciary is in the areas of real estate, title insurance, condominium, corporations, business, probate, guardianship, and estate planning. I am also experienced as in-house counsel for a private holding company whose holdings included sand and gravel mining, NASCAR racing, and trailer container manufacturing. As a member of the judiciary, I have had assignments in St. Lucie and in Indian River counties. For 4 years, I presided over all juvenile dependency, delinquency, probate, guardianship, mental health, substance abuse, and drug court cases. I am currently in my 2nd year serving, presiding over domestic relations cases while assisting the juvenile division. I believe that an effective judge is one who is a good listener, is respectful to all participants, and follows the law without legislating from the bench and without being swayed or influenced by others or by their own personal feelings. And I follow these principles every day. I have received the support of many members of our community, and I am proud to be endorsed by Catherine Hammond, retired magistrate, Circuit 19, Willoway Cattle and Sod out of Okeechobee, Jeff Smith, Indian River County Clerk of Court, and Daryl Lohr, Indian River County Sheriff. Thank you.
Thank you, Judge Griffin. Mr. Larsen.
Thank you, everybody, and thank you for having us and give us the opportunity to meet the candidates and talk to the people, because the pandemic has made things a little different this campaign. My name is Lou Larsen, and I want to serve as your next circuit judge. I've been an attorney on both sides of most of the kinds of cases that I will hear in our circuit court. I've also represented countless clients who needed the advice necessary to avoid their issue winding up in court in the first place. I've tried many cases and I've settled many more. After more than 20 years practicing law as an advocate, I'm ready to practice law as a neutral. A detailed resume outlining the many practice areas in which I am versed can be found on my website, larsenforjudge.com. That's a 4, number 4, judge.com. Currently, I'm the managing trial attorney for the litigation department of a statewide private law firm. Prior to that, I worked for approximately 10 years as an of-counsel attorney at Treasure Coast Legal, with offices in Stewart and Fort Pierce. For more than 10 years before that, I practiced law in the counties of the Treasure Coast as a sole practitioner, with and without associations with other local attorneys, including many cases in Indian River County. I'm versed in a wide variety of practice areas besides civil and criminal litigation, including family law, wills, trusts and probate, trademarks, copyrights, real estate, business transactions, and disputes of all kinds. I'm admitted in 6 states and the federal court, which covers our circuit. In 2004, I joined the only 7% of all Florida lawyers when I became board certified civil trial lawyer. This is a distinction that requires documented experience, extensive continuing education, peer review, and ethics in practice. I'm very proud of my board certification and have maintained it for the past 16 years. In addition to various law-related organizations, I've enjoyed working as a Little League umpire. I'm active at the YMCA, and I financially support Safe Space, the Humane Society, and United Against Poverty. I'm married to my wife, Catherine. I have a son and a daughter who both attended our local schools before attending colleges in our state. I also have 2 stepsons. After an extensive career as a working attorney in our circuit, I can tell you what I expect from a judge and what I will deliver as your judge. In my court, you will be treated with dignity and respect and given a fair shake. You will get your result without undue delay and without undue expense. I will work hard and never betray the trust you have given me in electing me judge. There would be no higher honor than for me to serve as your next circuit judge.
Thank you, Mr. Larsen. Judge Griffin, you'll have the honor of going first on this next question. If you became aware of unethical conduct on the part of a trial advocate in a case in which you were presiding, how would you handle it? Do you believe judges should be required to report attorney misconduct?
Well, yes, judges are required to report attorney misconduct. I have a particular circumstance where that has actually happened to me, where the attorney was not doing what they were supposed to do. And I struggled with it for a little bit as far as what to do about it. They were saying one thing, but doing something different. So I needed to investigate to make sure that I knew what I was talking about before I reported it. The rules require that we report it, and I did report it, and it was resolved. It was a situation where there was a misunderstanding, I believe, but not from my standpoint, but from the attorney's standpoint. We are required to report that, and if I see that, absolutely, I will do my duty and report that as required.
And Mr. Larsen, your response?
My response to that is that the bar rules, even for attorneys, require reporting of misconduct. As a judge, if I sensed that something was going on like that, or I thought that it might be unethical conduct happening, I would do what I could to stop it or prevent it. I would probably, depends on the situation, of course, but I would probably take the lawyers in the back, in private, talk about my concerns, let them air their positions, especially with respect to the impact on their clients. I would take corrective action if possible. If not, I would take that last step and report it to the Florida bar, declare a mistrial, do whatever other corrective action might seem appropriate at the time. It's hard to say given the lack of facts.
Sure, I appreciate it. Mr. Larsen, you'll be up first on this next question. How could the costs of judicial administration be reduced? Can you give us a specific example of how you have reduced costs in your law practice or court?
Well, cost cutting is always a high priority in any business and in any government function. I can start with what I've done in my own law practice, which I've started an online law firm, elawyer.com, where we have automated some of the process of estate planning. Not complicated tax sensitive estate planning, but just basic estate planning, drafting wills and powers of attorney and healthcare directives and such. Make sure, let the clients fill in the information, and then the documents are generated with a rough outline, followed by consultation, usually on the phone at eLawyer, and with Zoom. Now that this has become a thing that everybody does. And we've automated that and streamlined that to make it very cost effective. We've lowered the price of traditional legal services substantially. I think as far as the judicial system goes and the court system goes, technologies like Zoom and other technologies, which technology is always changing. And I would always be looking for the next cost cut and cost saving method without sacrificing justice or the process. But certainly we've seen it since the pandemic. Zoom has cut the cost of litigating, cut the cost for attorneys to practice law. I think it's also increased the level of service they're able to deliver. If they're spending less time in the car, less time on routine ministerial matters, there's more time for them to concentrate on the substantive issues in their clients' cases. And I think the clients ultimately benefit from better representation.
Thank you, Mr. Larsen. Judge Griffin.
Yes, there are ways to limit or reduce costs in the judicial process. One of those ways that is often used is mediation. If the participants, the clients can go to a mediation with an impartial third-party mediator without coming into court, taking up the time of the court, taking up the time of the attorneys in such a formal atmosphere. Everything is more relaxed with a mediator, and they're able most of the time to come to an agreement on their terms rather than the court making the decisions for them. That is one way to reduce the costs. Another way, as we've experienced with the COVID pandemic that has been thrust upon us and on a fast track, as everyone understands, Zoom and handling cases remotely was always something that was there and, you know, in the future, but because of everything that's happened, it's all been brought up to the present. Everyone has embraced it. It took them a little while to embrace it. Everyone has embraced it. Granted, there are rules that need to be established to get everything streamlined and to get everyone to know exactly what they need to do to act appropriate, to appear appropriate, and to maintain the dignity of the judiciary. However, I believe that those will be put into place. And because of the opportunity for participants as well as counsel, as well as the judiciary to appear remotely, it cuts down the cost for the clients tremendously. And they can attend, attorneys can attend several different hearings in one morning, for instance, that there would be no possibility that they would be able to do that if they have to travel to each courthouse and to each courtroom and be present in front of the judge. So those two ways are ways in which the costs can be and are reduced as far as the judiciary is concerned.
Okay. Thank you, Judge Griffin. And you'll be first on the next question. Last week, the Florida Bar announced 14 disciplinary actions, with 2 of those cases involved seasoned attorneys from Martin County. Do you believe the current system for disciplining lawyers and judges is effective? Why or why not?
Yes, I do believe that the current system of disciplining attorneys and judges is effective. We are all humans, judges, attorneys, litigants, everyone, we're all human. Mistakes are made. However, when those mistakes are made, consequences result from those mistakes. And it's the judiciary's responsibility to hold judges accountable. It's the Florida Bar's responsibility to hold attorneys accountable so that there is no perception from the public that there is a problem with the judiciary or with the attorneys that are licensed to practice law in the state of Florida. I did read those articles, and I absolutely believe, and it depends on the facts of each case. Each case is different. It depends on what the action was that was the cause for the discipline as to what the result will be. And I absolutely do believe that it is necessary and that it is effective.
Thank you, Judge Griffin. Mr. Larsen, your response.
I think overall the system works as far as attorney discipline. The one thing I would like to see, and it would be some kind of screening by the bar to weed out, initial screening to weed out the frivolous complaints, because when a citizen makes a complaint, which they should have every right to do, there should be some kind of screening that if their complaint does not allege any kind of violation of bar rules or anything that would be actionable by the bar, that the lawyer shouldn't have to respond to it, because it takes a lot of time sometimes to respond to those things. It takes file review, it takes resources, and I think that there should be, I mean, from the attorney standpoint, I think that as a working attorney, I know that these things happen, and a lot of not every client is happy. Most are very happy, but there's some that are never happy. And there should be some screening. Overall, I think the system works. There's certainly a right to due process, opportunity to be heard, and certainly the backup of the trial if the attorney claims innocence, which I believe everybody is innocent until proven guilty.
Of course. Thank you, Mr. Larsen. You'll be up first on the next question.
Sure.
Who are your judicial role models and why?
Well, without naming names, I know I tried a lot of cases, and I know the big difference there is between trying a case between a professional, competent, educated, knowledgeable judge and a judge that's sort of going through the motions and doesn't really know what they're doing. Sometimes, and I've also been in front of judges with proper judicial temperament. They're calm, polite, respectful, thorough, knowledgeable. And then I've been in front of the other kind of judges who are not so. And I think that sometimes judges are not so because they don't have the knowledge, they don't have the experience, they don't have the proper temperament to be a good judge. But I'm not going to name names. I think the judges that that may be listening to this know that I'm talking about them. I have respect for them. After trials, I always thank them for the good job that they did, and I certainly appreciate them. They make my life easier. And if I'm an elected judge, I intend to emulate those judges to make the process better, easier, fairer for everyone.
Okay, thank you, Mr. Larsen. Judge Griffin, how about your judicial role models?
Okay, the judicial role models that I have, I cannot pinpoint just one. Many of them, many of the judges in our circuit serve as role models. When you become a circuit judge or a county judge, you receive a mentor judge who helps you out in the first part, lets you know what goes on, what you need to do, and they share all the information with you to help you through the process. And mentor judges are absolutely role models for any judge becoming a new judge in the judiciary. The judges who make an impact on the lives of the citizens of our community are the ones that should be put on that pedestal, and good things should be said about those judges. They are the ones who, even if they make a decision that is against a party, if that party can go out of that courtroom and believe that they have been heard and that they've been treated with respect, then that is a role model of a judge. And as I always say, we can agree to disagree. So even if we don't get a favorable ruling, at least you can still respect them, and they are role models for all of the practicing attorneys before them, as well as other judges. And I could only hope to aspire to withhold those actions, to be able to listen, to be able to be respectful, as well as follow the law. So that's my answer as far as judicial role models, without naming anyone.
Okay, thank you, Judge Griffin. You'll be first on this question. How would you prepare yourself to handle cases involving unfamiliar areas of the law?
Okay, as a circuit judge, we are susceptible to be assigning to any division in the circuit, whether it be criminal, family, juvenile, whatever the division, you are susceptible to being assigned there in any county in the circuit. And for most of the divisions, there are bench books that are put out by the Florida court, OSCA, put out by OSCA in the judicial education section. Those are a wealth of information. There are courses that you can take. For instance, when I started the family division, the domestic relations division, a good thing to do, which I did, was I attended the family law certification course, and that was instrumental in learning all of the ins and outs of the family division. So each time you start a new division, there absolutely is a learning curve there. Even if you've been in that division previously, things change so often and so frequently. You have to become abreast of the new laws, the new cases, and just reading the cases every time they come in from the appellate court, as well as the statutes, and every time that they're revised. So all of that keeps you up to date, and those are the things that I do when I get a new assignment.
Thank you very much. Mr. Larsen.
Well, for me, there is really no area of the circuit court that I do not have some experience with, either handling cases or some indirect experience with, having researched some of the principles and some of the issues present in the cases, whether it be how a dependency action might impact a domestic case, or Some of the areas where I don't have a lot of hands-on experience in court every day representing clients, I certainly have indirect experience and knowledge. I would not rely on the lawyers to educate me. I don't think that it's fair to the clients and the people that are the parties in a case to have to pay lawyers to educate a novice judge. I would do what I need to do to learn and to get up to speed, whether it be by researching the actual the cases, the bench books, and the statutes, and treat the case as if I were representing the case itself. To come to educate myself so that I can best represent both parties as far as being a fair judge. My client would be fairness, and that would be my goal there. So the answer is I would educate myself and do the best job I could to understand everything that's happening in the specific case. And as I said, there isn't anything that's completely unfamiliar to me in our circuit.
Thank you, Mr. Larsen. You'll be up first on this question. What is your vision for the future of our judicial system? What changes would you advocate for and why?
Well, I think the obvious answer that jumps out is this leveraging of technology. I think that's here to stay, and it's here to change, and it's here to change the system. I think that we have to be more open to it. Traditionally, the legal system, whether it's the Florida bar or the judicial administration system, has been very slow to adapt to any new technologies. The pandemic has jumped us light years ahead. I think more of that's to come. I think we're going to be able to, even after the science solves the pandemic, I think that the benefits of remote use of technology are so apparent that there's going to be ways that we can actually do live jury trials remotely without sacrificing any integrity in the system. So that's the obvious answer. As far as other non-technology issues, I think that holding the lawyers to a high standard of knowledge about the law and responsibility to their clients is very important, especially since we have so many more lawyers than we did when I started. I mean, there's close to 1 million lawyers in the state, so that's a lot of lawyers.
Thank you, Mr. Larsen. Judge Griffin.
Would you please repeat the question?
What is your vision for the future of our judicial system? What changes would you advocate for and why?
Okay, the vision that I have for the future of the judicial system, at least in Circuit 19 in the state of Florida, is to maintain some of the technological advances that have been forced upon us because of the pandemic. As I stated previously, a lot of the rules need to be put in place to have everyone on the same page as far as what is acceptable, what is not acceptable, because there are still a lot of loopholes there. And it really depends on the specific judges on some of the things that are okay and not okay. I believe that, and I would advocate for, at least in our circuit, to have a circuit-wide position on each division. That's very difficult because each judge is different, but it would improve the understanding of not so much the attorneys, but the pro se litigants of what is expected for them in the circuit. For instance, if one judge requires this, I think all judges, might want to consider requiring the same thing so that everyone knows what to expect. That always, as everyone on this call knows, that is not always the best situation because everyone is different. Everyone has their opinions and everyone stands firm on certain positions that they have, regardless of what anyone else has to say. I would like for that to happen. I would also like for the forms that are in place by the Florida Supreme Court to be enhanced, and they are on a regular basis. They are improved. The judiciary receives, we are permitted to give input on those forms. And I just believe that more comprehensive forms for these pro se litigants would give them a lot better familiarity and comfort in filing their own proceedings. So it's the technological advances that I believe should remain, and that's the vision, and also the everything to be uniform in the circuit.
Thank you, Judge Griffin. You'll be first on this next question. In the realm of hate crimes, what are some of the issues in balancing free speech rights against the need to control offensive activity?
Okay, in the realm of hate crimes, did you say?
Yes.
Okay. Could you repeat the question for me? So I'm sure I have a clear understanding of your question.
Sure. In the realm of hate crimes, what are some of the issues in balancing free speech rights against the need to control offensive activity?
Well, I am not comfortable answering that question because of the restrictions that are placed on us by the Florida Code of Judicial Conduct. We are not permitted to discuss any issues that may come before the court. We are not permitted to discuss or respond to any type of political issue. And right now in our society, those types of incidents have become political in nature, somewhat, not always, but somewhat. So I respectfully will not answer the question because of those restrictions. I don't want to violate any type of prohibition that I need to follow.
Understood. Lou, would you care to take a stab at it?
Yeah, I'll take a stab. I'm aware of the canons. We're supposed to avoid appearance of inappropriate political activity, but I can say a couple of general things. Number one, our country was founded on civil disobedience. You know, when we broke from England, that was considered treason at the time. So civil disobedience has a place in our history and in our culture and in our law. I would protect the right to peacefully protest because that's guaranteed in the Constitution. Balancing that with the right to protect and the duty our government has to protect life and property of innocent people. And I think that, well, as far as your actual question about hate crimes, the legislature's defined that by statute. So I would apply the law as written, not legislate from the bench, and apply the law, statutory and judicial precedent in interpreting the law and the situation that would come before me as a judge. That's all I can say without getting into the specific scenario.
Sure.
Those general comments are certainly permissible.
Of course, I appreciate it, Mr. Larsen. You'll be first on this question.
Sure.
Have you ever been disciplined by the Bar Association or the State Commission on Judicial Conduct?
When I was a young attorney, I was in a fee dispute with another attorney, and it was very long and very painful for me. There was a bar proceeding, and I went to a trial, and I was found not guilty of dishonesty, deceit, or misrepresentation. I was reprimanded for some technical violations of not notifying another person who claimed disputed funds that I was holding funds and not keeping those funds separately. I dispersed money to my client instead of holding it pending the resolution of the dispute. Those things happened in 1995. The case was resolved in 2000 with a reprimand, and I've learned a lot from that. I've been hypersensitive to the rules, never come close to breaking any more rules. That experience, the system worked, and it taught a young lawyer a valuable lesson that he's never forgotten.
Okay, thank you, Mr. Larsen. Now, Judge Griffin.
Okay, thank you for this question. Yes, I have. And everyone probably already knows that. In 2014, when I put my name in to run for circuit judge, I made the mistake of I made the mistake of opening my campaign account, in other words, I wrote a check, loaned my campaign account money, opened my bank account, and then filed my paperwork with the Division of Elections. That is not the order that it is supposed to happen in. The order it's supposed to happen is you are to file first, then open your campaign account. This was in 2014, as I stated, and the one day I opened up my account, and less than 24 hours later, I filed my paperwork. I was disciplined by the Supreme Court. The JQC did an investigation. It was found, and I entered into a stipulation with them that I violated the campaign laws because of that method that I did it. I did it backwards. I should have done it the other way. It was not intentional. As I stated, I entered into a stipulation with them, and I was publicly reprimanded by the Florida Supreme Court. That is the most horrific experience that anyone could go through, and I would not wish that on my worst enemy if I had a worst enemy. It is an awful situation. It was a very traumatic time in my life, and the result, as I stated previously, when you asked if the system works, the system does work. It holds you accountable, and I believe at the end of the day, it's made me a better judge because I am very cognizant of how, if you do not scrupulously follow the statute, how that has a negative consequence on people's lives. In that situation, it was my life and my reputation. And, that is the only discipline that I've ever had, law enforcement, anything. So it was very traumatic. And I thank you for asking that question so that it can be brought out, because on the surface, people don't look into it. It's all public record, but you want them to know what happened. And that is what happened. It was a campaign violation, very serious. The JQC felt that it was necessary to have the public reprimand. And, I apologized and I stipulated to it because it was, at the end of the day, a violation. And so, yes, I have been disciplined.
Okay, thank you both for your answers.
Yeah.
Judge Griffin, you'll be first on this question.
Mhm.
The Federalist Society for Law and Public Policy Studies is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is empathetically the province and duty of the jury to say what the law is, not what it should be. Are you a member of the Federalist Society? Why or why not?
I am not a member of the Federalist Society. I'm not that familiar with the Federalist Society. Since I've been a member of the judiciary, I've heard a little bit about it, but I have not been a member, and I am not currently a member of the society.
Okay. And Mr. Larsen?
I'm not a member of the Federalist Society. However, I do read some of their publications. And as far as talking about some of the political issues they support and all that, I don't feel comfortable talking about that because of the canons. I do believe in saving money. I think that generally I'm a fiscal conservative, running a business, taking care of a family, living life in America. It's irresponsible not to be fiscally conservative. So that's, I'm also a strict constructionalist on the Constitution. I don't believe that the jurists should legislate. That's the job of the other branches of government. The judge's job is to interpret the law as written by the executive branch, the legislative branch, and as prior interpretations by the judicial branch as far as precedent. And that's what I intend to do. And if I'm elected judge, if I'm honored to be elected judge. Thank you.
Okay, thank you, Mr. Larsen. You'll be up first on the following question. It is a rather direct question. Why should voters support you rather than your opponent?
Well, I think that we have a kind of a crisis because of COVID. There's a backlog in the system. Our circuit needs judges that are versatile, that can handle any courtroom assignment on the very first day of work without a lot of training. Once jury's trials start to resume, there's going to be a problem. We need versatile judges that have the experience handling cases, that can address the issues. I think the depth and breadth of my experience is far greater than my opponent's. Although she is a one-term judge, that pales in comparison to the amount of years representing clients in the many different areas of law in our circuit that I am equipped to handle and address the problems caused by this COVID and the backlog of cases.
Thank you very much, Mr. Larsen. And Judge Griffin.
Okay. I believe, what was your question again? So I get the word right.
Sure. Why should voters support you rather than your opponent?
All right. I believe that the voters should support me over Mr. Larsen because I do have the judicial experience. I have a diversity of experience prior to entering into the judiciary. A lot of times, and this is common knowledge, a lot of times judges had a history of being a prosecutor, criminal defense attorney, and the judiciary needs diversity. And I believe that my experience gives the judiciary that diversity in my practice that I practiced before becoming a judge. Another aspect that I believe they should support me is because I am from this area. I was born here. I grew up here. I understand the communities. I understand the people. I know a lot of people in the communities. And I have that experience on the bench that Mr. Larsen does not. And that goes a long way. I have a proven track record on how I get along with others, how I get along with the court participants, the attorneys, the court staff, everyone. I have a proven track record there because some people can say how they're going to be as a judge, but I've done it and I have experience at it. And I believe that I am the best candidate for those reasons. And I'll go into a little bit more in my closing. Thank you.
Okay. Actually, the closing statements are what we'll be coming to next. I wanted to get you all back to your families in time for dinner. Mr. Larsen, I'll allow you to go ahead and make your closing statements first.
Thank you. I appreciate it. The court system is facing an unprecedented backlog of work right now and immediately needs judges who are experienced in many areas of the law to address the volume of cases that are piling up. I believe I'm the best one for the job. I submit to you that there is simply no substitute for real-world experience handling cases for being a great judge. Experience as a working attorney representing the clients and experience practicing the types of law before you is crucial to being in the best position to tackle the work that needs to be done. If you don't have much experience as an advocate, how can you be most effective as a neutral? Depth and breadth of legal experience set me apart from my opponent. My opponent highlights that she is the only candidate with judicial experience. However, this election is the first time she is facing the scrutiny of voters or anyone. She's never appeared on a ballot. Her incumbent opponent withdrew from the race, nor was she vetted by the Judicial Nominating Commission, nor appointed by the governor. I submit that her election materials asking the voters to re-elect her are misleading. It implies that she was a past preferred choice of the voters, which she was not. After all, appointed judges can't say re-elect, so why should she be able to? I submit that just because a judge is sitting in a position, that fact is not a good enough reason to retain her if a more qualified, experienced, and versatile candidate wants the job, especially in times like these. The taxpayers pay the salary of a judge and deserve the most experienced and qualified person in the position. I've been a working attorney for more than 28 years and a board-certified civil trial lawyer for 16 of those years. I've handled almost every type of case likely to come before me. I'm ready to fill any role our circuit requires, and I would be humbled and most honored to serve as your next circuit judge. Thank you.
Thank you, Mr. Larsen. Judge Griffin, your closing comments, please.
Yes, before I do my closing statement, I would like to point out that I wholeheartedly disagree with Mr. Larsen's categorizing my campaign materials as misleading. If you look on the Division of Elections website where it shows that I was elected, and that is how I obtained the position. I was elected without opposition because Judge Shack withdrew from the election. Now I'll get into my closing statement. You, the citizens of our circuit, are the reason that I am asking to be reelected to serve as your circuit court judge. For the past 5.5 years, it has been an honor and a privilege for me to serve, and I wish to continue doing so. While others can make predictions about how they will conduct themselves on the bench and what their judicial temperament will be, I have a proven track record of treating people with respect and of always allowing participants to be heard. My professional demeanor, calm temperament, and patience are extremely valuable when interacting with court participants, and I am always prepared for the cases over which I preside. I have earned the reputation of being a patient, kind, and fair judge. Given the changes forced on the court system due to the impact of the COVID-19 pandemic, judicial experience matters more now than ever before. I am well versed in the processes and procedures in place for conducting proceedings remotely, and this experience will prove crucial in moving forward. I encourage everyone to please let your voice be heard on or before August 18th by casting your vote for the candidate whom you believe will best serve the citizens and families of our circuit. I, Victoria Griffin, would be honored to receive your vote as Circuit Court Judge. Please visit the website at judgegriffin2020.com to learn more. And remember, your vote counts and your judge really does matter. Thank you and stay well.
Thank you both very much for participating in our forum. I've enjoyed our time together this evening. I certainly hope our viewers and members did as well. I'll see you all at the polls. Remember, early voting does start on the 8th and election day is the 18th. So get back to those families. Enjoy your evening. Thank you all very much.
All right. Thank you very much.
Everybody.
Take care.